New developments and the GOP congressional investigation into the Justice Department's probe of the 2016 Trump campaign. An aide to the House Judiciary Committee says they expect Fusion GPS co-founder Glenn Simpson to comply with a subpoena and appear before investigators for a deposition tomorrow. But Simpson's attorney says his client intends to take the fifth and refuse to answer any questions. Republicans say Simpson's decision does not surprise them as well. That's because his past testimony apparently contradicts the testimony of top DOJ official Bruce Ohr. Remember, Bruce Ohr's wife worked for Fusion GPS. Simpson claims he and Ohr never met to discuss the unverified Trump dossier that Fusion GPS helped spread around Washington. Of course, Ohr's wife, as I just mentioned, Nellie, worked for GPS. Judiciary member John Ratcliffe says he understands why Simpson would want to take the fifth.
I'm not surprised that Glenn Simpson is taking the fifth. He probably should. He's in real legal jeopardy. Very clearly, someone is not telling the truth. Remember, what we're talking about is the extraordinary measure of getting a warrant to spy on an American citizen. And if that was done under false pretenses with false information or false verifications, then that's violating someone's civil liberties under color of law.
All right, so Judge Knapp says, that's affectionate for Napolitano, says that there are two sides to this. What are they?
All right, so one side is Congressman Ratcliffe, whom we just saw, and other persons on the House Intelligence Committee with top security clearances say that they have seen all the documents that were given to the FISA court, and they have seen documents that were not given to the FISA court, and that if the court had seen what they saw, no warrant would have been issued, and this entire Mueller investigation would never have been commenced. That's one side. They want to expose this. They had persuaded the president to expose it. Israeli intelligence, who must have been involved, British intelligence, who must have been involved, dissuaded the president from revealing the applications. The other side is, wait a minute, you're in the middle of a criminal investigation. The subject of the criminal investigation is the President of the United States. You can't disrupt a criminal investigation for political reasons. You have to wait until the criminal investigation is over. Now, I can tell you from my own experience, and it's a bad experience, it is not uncommon to learn that people who came to you for a search warrant did not tell you everything you wanted to know.
Clearly.
I'm trying a case, and I say to the prosecutors, where did you get this blood? Well, some judge signed a search warrant to give it to us. I said, why'd you get a search warrant? There were so many other ways you could have gotten it. What judge signed the search warrant?
Right.
Judge, you did 3 years ago. Ah, but you didn't tell me you already had the blood from other sources. I'm suppressing the evidence. The consequence of misleading a court can be catastrophic to what the government's trying to accomplish.
Well, what if that court is secret? What if that court operates like the FISA court does, with absolutely no oversight, and essentially it's a rubber stamp?
That's why judges have to not bend over backwards for the other side, but ask the right questions. You're presenting me all of these documents. Is there anything else in your possession that I haven't seen? If they say no and the answer is yes, they've misled the court.
A quick suggestion, Melissa, and I'll go right to you. So what you and Kennedy are talking about, though, is power. Because in secrecy, we gain so much power. What if the court feels like it's so powerful it doesn't need to ask any more questions? It has what it needs.
Secrecy is dangerous to power. It enhances power. It permits the abuse of power, which is why I've been condemning this FISA court since it was created in 1978.
Look how long and hard journalists and politicians have had to work just to see that FISA warrant application.
But can I ask the question that was in the introduction to this? So we know that someone is lying about when they began talking about this dossier and shopping it around, and Bruce Ohr is, they're making the effort to make it seem like they got together and talked about it later rather than earlier. Now they've been caught in this lie. Why does that matter?
Because if the court is the recipient of a lie, if a lawyer or a person affiliated with the court, could be an FBI agent, makes a material misrepresentation of the court, that person's career is in jeopardy, and the court will never believe that person again. And if an innocent human being, here the president, though he wasn't president at the time, has suffered because of that lie, that person who suffered has redress against the liar.
Adrian?
Look, I guess I'm going to focus more on, the testimony here. And I can understand, frankly, why a lot of people would have concerns testifying in front of the Judiciary Committee, the Intelligence Committee, because so much what is released these days is cherry-picked information. People, will go in and testify even behind closed doors, and some of their testimony ends up getting leaked. That is not conclusive. So, I'm going to take the road of I can understand why anybody would have trepidation at this current stage testifying in front of the committee, because Republicans tend to cherry pick and
Only Republicans
leak some of this information.
From what we know about leaks.
Have you ever heard Adam Schiff hold court?
I'm simply looking at
politicians. I don't dispute that, but please divorce yourself of the notion that this is one-sided.
Okay.
Yeah, cherry picking is disgusting. That's why we advocate for transparency across the board.
I agree.